The new data protection law is here, and it will redefine how the healthcare industry handles data. On the 13th of November 25, the Ministry of Electronics and Information Technology have notified the final rules of the Digital Personal Data Protection Act by publishing it in the Gazette. The Data Protection Act was notified on 11th August 2023. It has taken over 2 long years to bring out these rules. Friends, we will attempt to understand this act and its rules and its impact on hospitals and doctors, and also discuss some practical steps to take that will help you remain compliant. Why is it important to be compliant? Firstly, this law is in force and you can be held liable if you are not compliant. And secondly, the penalties of the breach of provisions of this act lie between 2 to 250 crores for each occurrence. This is humongous. Let us first discuss some key rules defined under this law. First, the data principal is the one who owns the data, which includes your patient, their legal heirs, or their parents or lawful guardians in case of minors or vulnerable patients. Second, the data fiduciary means you, the hospital. If you are a very large hospital, there is a possibility that you may fall under the category called as the significant data fiduciary and may have to appoint a data protection officer who will be the authority that carries out all the legal obligations while representing the hospital. In any case, it will be wise to appoint one officer who will have the central responsibility to carry out all the obligations. Train your employees on this act, its importance, and put processes in place against data leakage. Third, consent has a deep meaning in this act, and it is the central character of this act. There will be a consent manager, which may be a third party that will control all consent given by the patient. The patient as data owner has several rights, including the right to give consent, withdraw consent partially, and demand deleting of their data. The consent manager will be the single point of contact for the patient and will act as a bridge between the patient and the hospital. Remember that this consent is different from the consent required for surgery and other interventions. Fourth, a data processor is the person to whom the hospital gives the responsibility to process or analyze the data. It could be a pathology lab, a data operator, and so on. The hospital becomes directly responsible for data collected, stored, processed, managed, or any breach by this data processor. Let us clarify this further. If this is a lab in the hospital itself, then the lab becomes the data processor of this hospital. However, if the patient goes to a laboratory that is not owned or managed by this hospital, then the hospital is not liable. There is also a data protection board under this act, which is constituted by the Government of India that will decide on the complaints of the patient. This board will be a digital office and all transactions will happen digitally. This board has the powers of a civil court. The patient can demand to see in an itemized manner as to what data is stored and used for what purpose. The patient has the right to erasure of this data with the same ease as which the consent was given. However, the hospital must retain data in a secure environment according to the Indian Medical Council Regulations 2002 and various other acts as may be applicable. Now, if there is any breach of data, then the hospital has to immediately notify the patient as well as the board of such breach within a stipulated time and take appropriate steps to contain the breach. Hospitals must decide how this entire data is stored and who has access to it. An audit of the entire process must be done and filed with the Data Protection Board from time to time. This means that all data collected must be itemized, encrypted, anonymized or tokenized and must be visible for a specific purpose, and the person viewing it must have the clearance and an audit record created. Unauthorized view of patient's data, even by accident, will attract heavy penalties. Remember, all data must be stored within India only, unless specifically notified. There are very strict rules for data belonging to children, but they have been relaxed for healthcare providers. All communications regarding notice or consent related data must have the provision to be shown in all languages under the 8th schedule of the Constitution of India. How much of this is practically possible remains to be seen given the costs involved and the accuracy of translation. The rule relating to registration of consent manager will be applicable from 13th November 2026. The rest of the rules will be applicable after 18 months from this notification, that is from 13th of May 2027. This is a reasonable time to prepare and implement these rules. Read, understand and follow the Act and its rules. Treat this law as part of your mandatory legal compliance. Be safe and practice safety. Thank you.